So I hope you're still awake after the heavy lunch. Again, thanks for staying with us. Part from our role as an international organization is to expand our cooperation with the local organizations. So today we are happy to announce that we will be signing a memorandum of understanding with two local associations. The first one we will be signing with the Qatar Engineers Society, a cooperation between the MCIArb and Qatar Engineers Society. So would you please welcome with me Engineer Khaled al-Nasr, the chairman of the Qatar Engineers Society, Dr. Nasser Al-Adba, the chairman of the Chartered Institute of Arbitrator Qatar branch, Thank you so much. I would like to invite to the stage Mr. Mubarak Al-Sulaiti, the chairman of the Qatar Lawyer Association. The last, we as a MCIArb is committed to an equal representation. So today we will invite equal representation in arbitration pledge to be signed on behalf of the Chartered Institute of Arbitrators Qatar branch. So I would like to welcome Antonio Pert, that Dr. Nasser will be signing on behalf of the branch. Thank you, Dr. Nasser. Thank you, Antonia. Thanks for the guests. Just give us a few seconds while my colleagues will prepare for the third panel. So I would like to invite my colleagues on the third panel to join us on the stage. So would you please?
Good afternoon, everyone. We would like to welcome you to the third panel, which is regarding the highlights on international arbitration. We would like to welcome our colleagues, Ms. Myriam, Dr. Aouni, Dr. Wael, and Mr. Khaled. My name is Mohammed Elayyan. I'm a board member of MCIArb Qatar, and I'm a partner at CA International, and I would welcome you all. First, we would like to welcome Ms. Myriam to start this panel. Ms. Myriam is a senior counsel with Marri and Hage law firm office in Qatar and leads the firm's arbitration and ADR practices. She previously held the position of partner and head of arbitration in a well-established law firm between Lebanon and Saudi Arabia. She has more than 15 years of experience in the conduct of international arbitration proceeding in ad hoc and institutional. Myriam was selected to feature among 40 prominent female arbitration practitioners in the Arab world by LexisNexis Middle East and was featured on the Legal 500 Arbitration Private Practice Power List, Middle East region of 2023. Myriam is a qualified lawyer registered with the Beirut Bar Association and a member of the ERA Pledge Middle East Subcommittee and the Greener Arbitration Campaign. She is a lecturer in international arbitration at the School of Law of the Holy Spirit University of Catholic since 2017. Ms. Myriam also holds a master's degree, a DEA in commercial law from University of Pantheon, Assisi, Paris, and a law degree from the University of Saint Joseph in Beirut. She also contributed to several scholarly articles and studies in Arabic, French, and English. So without further delay, Ms. Myriam, please take the stand.
Thank you for the introduction. Good afternoon, everyone. I'd like to thank first the Chartered Institute of Arbitrators, Dr. Nasser Al-Abda, Chair of the Chartered Institute, Mr. Saad Higazi, Vice Chair, and of course all the Chartered Institute's team for their support, especially Nurul Sabri, who's been very patient with me throughout the couple last days. So I will be discussing with you today a very important topic that is up until this date very controversial, despite the ink that has been spilled discussing time bar clauses in construction disputes, especially under Qatari law. I remember when I first came to Qatar, the first topic that was ever mentioned to me was Article 418 of the Civil Code regarding time bar clauses and the discussion of whether it applies to time bar clauses or not. I thought at first that the answer would be straightforward. However, looking at the article itself and at the nature and the drafting of time bar clauses the way we know them in construction disputes, it is not evident, at least in civil law countries and for civil lawyers, to be able to strictly say that it is prohibited under Article 418 of the Civil Code. Just a second, do I use this? Okay. So, yeah. So what are time bar clauses, or time bar? What is time bar actually? Time bar is a word that I started encountering when I first started working. It's an English word. It doesn't have an ad verbatim synonym in Arabic. And it is broad. It relates to any time limit that would affect a party's right, generally by the elapse of which a right is lost or the right to claim it is actually lost. This is what time bar clauses are in general. However, in civil law countries, there is no specific wording. We call them in general prescription, and prescription can be both, can extinct a right or help you acquire a right. So basically, there are two types of prescription in civil law: extinctive prescription and acquisitive prescription. This is the reason for which it is not easy to just refer to time bar as the equivalent of prescription provisions in civil law countries. And in Arabic especially, it has a very specific term called taqadum or murur zaman in certain Arabic countries, which means elapse of time and not time bar. Because we don't know actually what does it bar when it comes to time bar. There is one other very interesting concept that is rarely discussed. It is the délai de forclusion, what we call foreclosure deadlines, which are time limits in civil law countries that not only would affect the right to claim. These cannot be suspended. They are strict deadlines that cannot be suspended unless through a court order. So this is also a specific term that is even more specific in civil law countries that makes it harder to just categorize time bar clauses or what common lawyers refer to as limitation clauses in civil law countries. Now, under Qatari law, and there is under Qatari law, and this is very also important, I've noticed under Qatari law, the prescription is governed by Articles 4. Prescription is governed by Articles 430 to 418 of the Qatari Civil Code. Okay, sorry, I don't know why it's not. Okay, so basically it is governed by Articles 430 and 2418 of the Qatari Civil Code. And what is interesting is that Article 430 expressly mentions the effect of extinctive prescription under Qatari law. It says that it bars the claim or the right to file a lawsuit or enforce a right. It doesn't actually extinguish the right itself. And this is important because even if you fail to claim your right within the deadline, which is 15 years as a general, the general deadline, 10 years in commercial disputes, your right is not extinguished itself. It remains, but you cannot actually enforce it yourself. This is known, this is what we call موجب طبيعي or obligation naturelle, natural obligation. The actual impact is that when a debtor voluntarily pays, even if the deadline or the prescription has actually occurred and time has elapsed, his payment or performing the obligation is still considered a due performance, and the creditor and the debtor cannot claim reimbursement, restitution of any amounts it voluntarily pays under after the elapse of the prescription. Now moving on to the controversial article, and this is one of the most important. Yeah. Yes. Okay, so yes, I do, but it's not working.
This is the speaking. What is the point?
I don't know. Okay. Okay, so that was a problem. Okay, actually, so moving on to, please, the previous one, please. So moving on to this specific controversial article, which is the basis, actually the article relied upon in construction disputes by especially debtors of obligations, employers or contractors or subcontractors, to invalidate time bar, what is known as time bar clauses in construction disputes, is this specific article. It says, prescription may not be renounced prior to the establishment of the right thereto, nor any agreement may be reached on period of prescription that is different from the specified periods in the law. Which means, practically, that you cannot agree to shorten the 10 or 15 year or any other legal time limits or extend them. Now, some of the debtors have relied actually on the previous article to say that prescription cannot be waived, and that actually before the right is established to invalidate time bar clauses. However, having researched this specific provision, it seems that prescription here generally, the first part relates to the debtor, which cannot waive because prescription is a right to debtors to ensure the stability, to ensure diligence for a creditor who wants to enforce their rights. This specific first part of the article is destined to actually protect a party after the elapse of 10 years from having to again be surprised and deal with a case it thought was long left or waived. A debtor cannot, and this is established in Qatari law, cannot avail itself, cannot waive a prescription until there is prescription. So until his right to prescription, the right to prescription has actually been established. Practically speaking, and this is important because some would rely on this clause for the time bar, the first part, I don't think it is directly relevant. For example, if after 10 years a creditor claims a right that is prescribed and the debtor does not challenge, actually, in court, raise the prescription, in time, he is considered as having waived the prescription and he will be ordered to pay. And this is actually one of the cases under this article. So the previous one, please. The second most important article is that most important effect is that time bars cannot be shortened. Time limits cannot be shortened because you need to at least ensure that the party has sufficient time to exercise its rights and to avoid that the party waives the right before the legal time limit. The only exception actually in this specific clause is implicit waivers by debtor as per the first clause and not for the shortening of time limits which cannot be implicitly made. And of course, prescription is known because in civil law countries, there are no rights, perpetual rights. Rights are not, should be prescriptible after a certain time to ensure stability. You cannot be held a prisoner of an obligation infinitely. This is the principle, save for the exception of the law. So this should be also kept in mind. Now, this is an example of what we call a time bar clause in construction disputes. And generally, debtors rely on this clause, and tribunals as well, to deny a party, which is generally the creditor, the right to claim payment for additional costs in the event it did not issue a notice within 28 days. From the date it became aware of the circumstance that has actually caused the additional costs. So basically, under this clause, a contractor might receive a variation order, for example, or an instruction. If he reads the instruction from the employer and does not, and believes and considers himself as entitled, is important, believes that he might be entitled to additional compensation because of additional works, he should immediately and within 28 days issue a notice of claim informing the employer that actually, listen, there might be additional costs, so I'm reserving my rights. And if he doesn't do that, and this is the very strict effect of the failure, it is that he will no longer be entitled to additional payment, and most importantly, the employer will be discharged. Discharged, it means that not only he has no longer the right to claim, there is actually a waiver. He loses completely the right to claim. So, how do we know whether this clause falls within the restrictions of Article 418? Two things. Does it actually entail a debtor waiving its prescription rights? This is not related to the obligor. Second, does it shorten the time limit to claim a right? Does this clause shorten the time limit during which a party, here the contractor, can claim additional payment to 28 days? There are two positions. If it doesn't, actually it doesn't fall within clause 14. Sorry. So what are the arguments? What are the arguments? Please, next. That what are the arguments excluding this provision? The main argument, and by the way, not all prescription clauses are similar to the one in Qatar. In Egypt, maybe in France, it's much different today. So this is really specific to Qatar and the region. When you send the notice, there is no right here. The right does not exist. And under Article 410, prescription only starts running from the date the right becomes due. So when there is a notice, during the time the notice is issued, there is no right. So prescription does not start. So if there is no point of start to prescription and the right has not yet been created, as per Article 410, there is no prescription, no one is waiving their right to prescription, and no time limits are being shortened, so it does not fall within the ambit of Article 418. And the main argument is that the notice precedes the right and provides a condition for entitlement, because the contractor will only be entitled if actually, and this is the position, I'm not defending it, if he issued timely the notice. And they defend, those who defend this position actually refer to suspensive clauses or الالتزامات بالأجل الموقف, that الأجل الموقف أو الواقف, suspensive clauses which exist in civil law countries where an obligation is suspended until a condition is met. In this case, issuing a notice. And there is a lot of arguments in favor of the suspensive condition, because actually, in fact, payment becomes due if the notice is issued. It's a suspensive condition. Suspensive conditions are actually applicable under Qatari law, and this makes the time bar clause valid. In a recent ICC decision, the arbitrators have actually adopted this position and barred a party from compensation up to 70 million because they did not timely issue within 7 days notices of claim for more than 5,000 instructions that were issued. Practically speaking, the employer has bombarded the contractor with instructions that may or may not have been clear, and then because the latter didn't manage to issue a notice within 7 days, he lost its right. And they were convinced that this is a suspensive clause, and at the time, all of the arbitrators had common law background and considered it to be similar to condition precedent. In another recent case as well, less recent case also, this time civil law arbitrators have also enforced time bar clauses on the basis that they include a waiver of rights and not a prescription. Waiver of rights is actually possible and recognized under Qatari law. Finally, what are the arguments in support of the application of Article 418? And civil lawyers here, I know, because I feel it, there is something when I tell you that actually they had to pay 70 million of works performed just because they failed to issue a notice. There is something wrong, at least for civil lawyers. The reason, especially if you apply suspensive conditions, for the following reasons. Actually, a suspensive conditions relates to the performance of an obligation. And it has a specific regime under Qatari law that requires the event to be future and uncertain, and it requires, and this is the most important, for the right to be created or established or enforced at the moment and at the time the condition is realized. If we follow the rationale of the notice of claim, the question would be, would the contractor be entitled to compensation automatically once he issues the notice? No. Why? Because compensation is linked to whether the actual works have actually led to the variations have led, for example, to additional works. Sometimes contractors issue notices, but at the end of the day, in fact, the works have not led to additional costs, there is no compensation. So the first point is defeated. Notices do not actually create a right. Second, under Qatari law for the suspensive conditions, a party, here, the creditor, can always, even where condition has not yet been materially realized, can actually take measures to preserve its rights. And the question is, can a contractor go to the court and say, listen, I haven't issued a notice yet, but I want interim measures to preserve potential additional costs that I might incur? No. So the second condition, second criterion for the suspensive condition is not met. Finally, and most importantly, under Qatari law and in general, a suspensive condition cannot be reliant on the sole, let's say, will or action of the debtor, in this case the employer. When the employer issues a variation order, if the employer does not put, he can put like vague data and then issue it, the contractor might think that there are no additional costs, and this would circumvent compensation. So this is the main argument. The other main important provisions you can rely on, so suspensive condition, no. The other provisions is good faith performance of contracts, justice, but also the actual impact of time bar clauses, which serves the purpose of Article 418, which is to prevent a party from waiving a right or losing a right prior to the 10-year period where it could claim it, and practically this is what happens if we apply the time bar clauses. One other important article, I think, before we conclude, is Article 63, which relates to the abuse of rights, because you cannot use a right if it will inflict substantial damage on one of the parties. And the sum of the articles actually also, under Islamic law, what we call principle of prevention or contradiction, which means you cannot avail yourself from an action that you have yourself inflicted. For example, if it was the employer that was the reason for which the contractor couldn't actually identify the additional cost, this principle would apply. So we can cite the prominent Hanafi, please can you go just 2 slides before? Prominent Hanafi jurist, which talked about the inconsistent statements, Majalla, Article 100. And by the way, these are civil law and Islamic law principles that totally, maybe they precede or are simultaneous to estoppel, but that are enshrined within the civil law and Islamic law and would ensure and apply to easily to time bar clauses. This is the reason for which, his last slide. This is the reason for which many civil law countries have actually refused to enforce time bar clauses, and there is a very high likelihood that Qatari courts would, although to the best of my knowledge, there are no published, at least to the best of my knowledge, judgments on time bar clauses in construction disputes. If this is pleaded before Qatari courts, I believe chances are they will not apply the time bar clause. And thank you.
We would like to thank Ms. Myriam for such a wonderful and very rich presentation on a very controversial topic, we can say. Now we would like to welcome Dr. Wael Shalaan. Dr. Wael Shalaan is an Associate Professor of Civil and Commercial Procedural Law. He is from the Faculty of Sharia and Law at the Azhar University in Cairo. He is a Senior Legal Counsel at Ministry of Justice Qatar. He is delegated legal counsel to the Minister of Social Development and Family Office. He is Secretary of the Committee of Expert Affairs, and he is a certified arbitrator and lawyer. Dr. Shalaan held several administrative and executive positions at Al-Azhar University before joining the Ministry of Justice in State of Qatar as a senior legal consultant in 2015. Dr. Shalaan also participated in drafting and reviewing many Qatari legislations, laws, and decrees. He participated in writing and drafting civil or legal opinions in many states' major lawsuits. Since joining the ministry until now, Dr. Shalaan has many articles and research papers published in peer-reviewed journals in both Arabic and English on international arbitration and civil and commercial procedural law. So please welcome Dr. Shalaan.
Assalamu alaikum wa rahmatullah. Thank you, Dr. Nasser, for this invitation. Really appreciate it. It's a pleasure to be here between all these among pioneers and scholars. So thank you very much. Today, I will talk about the security for cost in international commercial arbitration. Security for cost in international commercial arbitration. Sorry. Please, the first slide. As you know, security for cost, and this meaning is kind of intermeasure. Article 17 in the model law, in the settled model law, say unless otherwise agreed by the parties, the arbitral tribunal may, at the request of the party, can grant interim measures. A, measures to maintain and restore the status quo pending arbitration, the determination of the dispute. In this meaning, the anti-measure security for cost is one of the weapons you can protect your assets, protect your rights in this arbitration. Security for cost is kind of sum, is money, condition. To be hearing your case, you have to pay this money. You can say this is kind of a financial precondition if you want to go your case, if you want to hear your claim. You can ask, you can submit your application for the arbitral tribunal before start anything in the hearing, ask them to grant you a security for cost. This could be a bad situation for the claimant, particularly if it's in financial problem. When ask him before, if you want to start your claim, you have to pay. I will pay already my share on expensive, my cost, the institutional cost, I already paid. No. This is another kind of cost. This guarantee, this kind of guarantee. And in this case, you have just one option. You have to comply with the arbitral tribunal request, or you'll dismiss the case. Pay, take it, or leave it. Second, please. In this meaning, security for cost could be a kind of double-edged sword. Maybe it's a good tool to protect your rights, or maybe you can use to preclude or impede the claimant case. For example, if you want to start, you have to pay. It's very hard for me. This could be a dirty weapon. But for this meaning, many arbitration or many countries that recognize these arbitration tools but set some conditions to guarantee these kind of measures. For example, for example, the states where the parties' residence, body financial situation, the timing of the request of the application. Here, actually, there is no standard, universal measure or universal standard to guarantee such measure. But some institution, arbitration institution, put some guidelines to guarantee to how to use our criteria to how to use this measure. Charter Institute put kind of guidelines on security for cost. It's called Application for Security for Cost. These guidelines contain some sets, some norms, how to use or how the arbitral tribunal decided to guarantee this whether or not, this measure or not. For example, party nationality or residence, where you stay in the same territory or stay in other states, what the financial circumstances, insolvency, you have bankruptcy or no, you are in good position or no, if you have good or bad faith or no, timing, as we said before, timing of the application. When exactly request this measure. Before start or during the process, during the hearing, when exactly? And the arbitral tribunal will decide to grant this measure or not. Security for cost face some defects, actually just 3 points. You can say security for cost is violate confidentiality of arbitration. You can say it violate parties' rights or human rights for access to justice, or you can say this is not clear criteria. I'm not sure about the situation under Qatari law. I've never asked to grant this measure before as an arbitrator. I'm not sure about my colleague. The request, is there anyone of you face this request before or use it as a weapon to hinder or to impede the process or no? I'm not sure. But the 3 points, you can target the security for cost from this issue. The first one, say security for cost is violate the confidentiality of the arbitration. Because the arbitral tribunal to decide to grant this measure or no, need to assess your financial situation. So I will ask the claimant to present some highly confidential document, bank statement, business market share, show me what your situation, give me a certificate from the bank about your statement, whatever. I will ask him to present all this highly confidential, and all this document will to be before the arbitral tribunal to decide it and maybe exposed during the hearing. This one said you can say this security for cost breach this confidentiality. But from the other side say no, security for cost is another meaning just self-enforcing measure, which I likely may any other measure. This you need to, as a claimant, you have to submit all these documents by yourself so you can decide it. Submit it, disclose all this information or not. So this is just have one option, I said before. You say yes to submit your document or no. But in this case, we'll face a very bad position. Maybe your case may be dismissed. It's a very bad situation for your side. Indeed, we can say security for cost is protect confidentiality of arbitration, because as a respondent, I will not submit anything. I will not go through this process or this hearing, this case, until you expose you. I know how you can do it or not. You can go the end and you can recover my money or my assets or not. I don't know. So I will not go this process, this case, this proceeding until I know what exactly your ability to pay my money, if I won the case, sure. You can say security for cost violate the party's right to access to justice, because I will put a precondition. If you want to go to the court, to the tribunal, you have to pay. If I can't pay, then you will not hear your case. This could be form a kind of human rights violation. Yes, if I can't pay, I will not hear it. I can't ask you to give my rights if I cannot pay, if I can't pay. This may be a very bad situation for small firms. When small firm, for example, submit a case, arbitration case against a big firm, the big firm can ask to submit to ask the arbitral tribunal to grant this measure. For example, I need $1 million as a security for cost. The small firm will be in a very bad situation if she can't pay. If you can't pay this amount of money, so what's happened? What's the solution in this case? So I think the arbitral tribunal have to decide it fairly in this position, to have to make a balance between all this. Anyway, no. Here, no, I think you can go back. Here, if you can say this security for costs can form a human rights violation, so you know, actually, security for cost maybe can protect the rights. It protects my rights as a human, as a respondent too. We have two parties in this case. If you can't to go to the court, you go to the tribunal, you have to pay. And from my side, I'm not hearing your case until you can recover. I can recover my expenses in this case. So it's kind of balance. It's not human rights violation for both. If you can't go, you need my money. So I think the arbitral tribunal in hands of arbitral tribunal decided to grant such measure or not. No. Here, the third point. Say there are no criteria to grant security for cost. What exactly the criteria to know our arbitral tribunal to grant such measure? How to decide it to grant this measure or not? What exactly you look for from the claimant? His circumstances, financial circumstances, or what? What do you look for? What's the absence? What's the criteria here? There are no criteria. This totally in my hands as an arbitrator, as arbitral tribunal. We call this, the next slide, say this in all modern arbitration models, law rules now give the arbitral tribunal a wide range of discretion, power to decide it in this issue. This is depend on arbitral tribunal experience. For example, in ICC case in 1994, ICC tribunal rejected the security for cost application because it considered the respondent in bad faith. So, if you submit your application to security for cost, you will not grant it unless you show the arbitral tribunal you have a good position to pay, your claimant is in very bad situation, financial situation. If you are in bad faith, you will not get this grant. In conclusion, I think now you have, I'm not sure, good idea about this measure with or against, I'm not sure. We'll use it as a weapon to handle the arbitration process, or use it as a weapon to save your client rights. I'm not sure what exactly. But still some concern about this measure will still now. You can use it in good or bad faith. Thank you very much.
Thank you, Dr. Shalaan, for this. Our next panelist will be Dr. Aouni Almousa. Dr. Aouni Almousa is an assistant professor of private law and alternative dispute resolution at Lusail University in Doha, Qatar. He is a counsel at Alexander and Partners, Berlin, Germany. He is a trainer also for arbitrators at Qatar International Center for Conciliation and Arbitration, KICA, as well as at Kuwait Commercial Arbitration Center. Dr. Aouni is specialized in international commercial arbitration. In addition, he maintains a broad commercial practices with a focus on international business law, foreign investment, and international commercial arbitration in the Middle East and North Africa. He is particularly experienced in matters relating to Qatar, Saudi, United Arab Emirates, UAE, Egypt, and Syria. He advised in commercial transactions, strategic investments, joint ventures, and regularity compliance, as well as matters involving state contracts. The recognition and enforcement of foreign judgments, employment laws, and trade finances is part of his specialties. So we would like to welcome Dr.
السلام عليكم جميعا ومساء الخير. طبعا بتحب اتشكر القائمين على الكونفرنس على هذا التنظيم الرائع وعلى الدعوه. راح ابدا مداخلتي مثال تعرضنا له بالحياه العمليه بالنسبه للممارسين بالتحكيم، اكيد مر عليهم هذا المثال. طرفي عقد ابرموا اتفاق تحكيم، حددوا القانون الواجب التطبيق على صحه اتفاق التحكيم الذي يجب ان يخضع له اتفاق التحكيم من حيث بحث شروط صحته وايضا مكان التحكيم. ولكن الطرفين ينتموا إلى دولتين مختلفتين. طبقاً لقانون دولة أحد الأطراف من الجائز أن يكون الموضوع غير قابل للحل عن طريق التحكيم، أي هون تفقد الأهلية الموضوعية لاتفاق التحكيم. ولكن المثال اللي أنا شخصياً اشتغلت عليه حقيقة أنه اختاروا الأطراف مكان بلد التحكيم، والقانون الواجب التطبيق بدولة يخضع له هذا النزاع إلى التحكيم، ممكن جائز فيه الصلح وبالتالي جائز التحكيم. ولكن حقيقة بالحياة العملية لما يصير نزاع أحد الأطراف بيلجأ للتحكيم كما هو متفق عليه، والطرف الآخر يلجأ إلى محاكم دولته للاستفادة من موضوع أنه عدم قابلية النزاع للحل عن طريق التحكيم، وبالتالي لتعطيل العملية التحكيم. حقيقة من وجهة نظر عملية في الطرف الآخر هو يعتبر طرف سيء النية، استفاد من شغلة موضوعة بقانون دولته، مع أنه بإرادته أخضع نفسه لقانون مكان ثاني ومكان التحكيم آخر. حقيقة دائما كنا نسأل نفسنا ما هو، هل هناك إمكانية لإصدار أمر لهذا الطرف بوقف الدعوى القضائية أمام المحاكم الأجنبية أو ترك هذه الدعوة؟ وأيضا هل هناك إمكانية علاوة على ذلك لمطالبته بتعويضات؟ لأنه نحن مثل ما بنعرف أنه الطرف المهتم بالتحكيم أكيد رح يقدم طلب لبدء الإجراءات التحكيمية، ومن حقه ذلك أيضا، لأنه بالأساس إن متفقين على قانون معين وعلى مكان معين. ولكن إذا الطرف الآخر راح قدم دعوة أمام محاكم أجنبية، فهو هون مضطر أحيانا أنه يوكل محامي بالبلد الثاني ويتبع الإجراءات. هذا الشيء ممكن يسبب له كمان مصروفات غير ضروري. حقيقة بالبراكتس الأوروبي حاليا وبلشت تنتشر أيضا بألمانيا موضوع أنه إعطاء هيئة التحكيم سلطة إصدار أمر بإيقاف دعوة تم بدءها في الخارج بالمخالفة لاتفاق التحكيم أو الالتزام اللي ألزموا فيه الأطراف أنفسهم، وأيضا المطالبة بتعويضات. ولكن على ماذا تستند هذا الشيء؟ حقيقة استندوا على إمكانية إصدار هيئة التحكيم لأوامر وقتية وتحفظية. طبعا بداية لما بدنا نتحدث عن طبعا رح نتحدث عن المواضيع التالية. بداية مفهوم مصطلح أمر وقف الدعوة، وأيضا المرتكزات التي يستند عليها مؤيدو هذه الفكرة. طبعا ما هي الفوائد العملية؟ ليش بنقوم بهذا الشيء؟ ما هي فائدته العملية؟ هل هناك فائدة عملية من ذلك؟ هل هناك إشكاليات؟ وطبعا هل هناك إمكانية لأنه هذا الشيء يتطبق في القانون القطري؟ طبعا فيما يتعلق بمفهوم مصطلح أمر وقف الدعوة، هو شيء كان مطبق حقيقة في الأنظمة الأنجلو ساكسونية، بعدين بلش ينتشر بالأنظمة الجرمانية. في هناك حكم لمحكمة العدل الأوروبية بهذا الشيء بقضية غازبروم وليتوانيا. بعدين المحكمة العليا الألمانية كمان اتطرقت للموضوع وحكمت بتعويضات بسبب مخالفة أحد الأطراف الاتفاق. الطرفين اتفقوا على تحديد اختصاص قضائي لمحكمة معينة، فقام أحد الأطراف برفع دعوى أمام محكمة أخرى، فهون بهي الحالة حكموا عليه بتعويضات بالنسبة للمصاريف اللي ترتبت للأطراف. طبعا أوامر وقف الدعوة اسمها بالإنجليزية أنتي سويت إنجكشن، وبالألمانية بروتسيس فيرونكس فيربوت. طيب ما هي المرتكزات التي استند عليها مؤيدو فكرة إعطاء هيئة التحكيم سلطة إصدار أمر وقف أو ترك دعوى قضائية في الخارج؟ بداية ثبوت الاختصاص في فصل في النزاع لهيئة التحكيم. هناك إجماع بأن هيئة التحكيم هي اللي تفصل باختصاصها. طبعا قوانين كل الدول المأخوذة من الأنسترال بتعطي هيئة التحكيم هذا الاختصاص competence. بعض الدول بتعطيها اختصاص حصري بذلك، بعض الدول بتعطيها اختصاص مشترك مع المحاكم. يعني في الأطراف يروحوا على هيئة التحكيم ويبحثوا في صحة اتفاق التحكيم طبقا للقانون الواجب التطبيق، أو ممكن يستعينوا بالمحاكم. مثلا النظام الألماني ممكن الأطراف يستعينوا بالمحاكم لبحث صحة اتفاق التحكيم وبالتالي اختصاص هيئة التحكيم. طبعا بعدين استندوا على لحتى نعرف ليش الطرف الثاني يعتبر قد خرق التزاماته، ولماذا يعتبر الطرف الثاني في موقف أنه هو شخص سيء النية. نحن بنعرف أنه هناك آثار إجرائية لاتفاق التحكيم. آثار إجرائية لاتفاق التحكيم إذا كان الاتفاق صحيح فهو يقيم أو يؤسس اختصاص هيئة التحكيم، وفي نفس الوقت يسلب أو يحجب اختصاص المحاكم القضائية في النظر في النزاع. لأن نحن كلياتنا بنعرف أنه هيئة التحكيم يجب عليها في البداية أن تبحث في اختصاصها، وبالتالي تبحث إذا كان اتفاق التحكيم صحيح أم لا من أجل وحدة النزاع. ولكن هناك آثار عقدية غير الآثار الإجرائية الموجودة أو التي تترتب على اتفاق التحكيم. اتفاق التحكيم يرتب آثار إجرائية ويرتب أيضا آثار عقدية. من أهم الآثار العقدية التي يرتبها اتفاق التحكيم هو التزام الأطراف بعدم اللجوء إلى القضاء العادي أو القضاء التقليدي أو النظامي لحل النزاع. فهون لما أحد الأطراف بيلجأ للقضاء لنظر النزاع يلي اتفقوا الأطراف إلى حالته على التحكيم، فهون هو خرق التزام عقدي حقيقة. وخرق الالتزام العقدي بيرتب طبقا إن كان للقانون الألماني أو القانون السوري أو القانون القطري تعويضات. أي حدا بيخل بالتزاماته العقدية ممكن نطالبه بتعويضات عقدية. حقيقة في كتير دعاوى تحكيمية في ناس ما عم تنتبه لهذا الموضوع، أنه الطرف الآخر ممكن نطالبه بتعويضات. طبعا هل هناك سلطة لهيئة التحكيم حقيقة بإصدار أوامر بوقف الدعوى القضائية أمام القضاء الأجنبي والحكم بتعويضات إذا قام أحد الأطراف بالمخالفة لاتفاق التحكيم برفع دعوى أمام القضاء الأجنبي؟ طبعا ممكن عن طريق اتخاذ أوامر تدبيرية وتحفظية. هلا بدنا نشوف نحن بالقانون القطري أنه من حق هيئة التحكيم اتخاذ أي تدبير من شأنه عدم المساس بالعملية التحكيمية، وهذا بيدخل بهذا الموضوع. هناك بعض الأشخاص اللي بيجادلوا بموضوع سيادة الدولة، أنه هل من الجائز لهيئة خاصة اللي هي هيئة التحكيم أنها تصدر أوامر بوقف دعوى أمام محكمة أجنبية؟ طبعا الناس اللي بتجادل بهذا الشيء تم الرد عليها بأن هذه الأوامر لا تصدر إلى المحاكم الأجنبية ولكن تصدر للأطراف. أوامر وقف الدعوى أمام القضاء الأجنبي تصدر للأطراف ولا تصدر للمحاكم الأجنبية. إمكانية تنفيذ هذا الأمر أمام المحاكم الأجنبية فيه إشكالية طبعا، لأن إذا بدنا ننفذ هيك أمر أمام المحاكم الأجنبية أو بالدول الأجنبية الثانية لازم يعتبر حقيقة حكم تحكيم. هناك بعض هيئات التحكيم اللي بتلجأ إلى إصدار هذه الأوامر كحكم جزئي من أجل إخضاعه لاتفاقية نيويورك وبالتالي إمكانية الاعتراف فيه وتنفيذه. طيب شو بيفيدنا نحن إذا أصدرنا أمر وقتي أو أمر تحفظي بوقف أو ترك دعوى قضائية في الخارج وما حسنا ننفذه؟ الإمكانية هون أنه إذا صدر حكم قضائي في الخارج ما رح يحسن يتنفذ بدولة مكان بلد التحكيم لأنه في حكم سابق عليه صادر بهذا البلد. هي حقيقة الفائدة العملية. إضافة إلى ذلك هون بيكون في إمكانية لهيئة التحكيم للحكم بتعويضات على الطرف الآخر سيء النية وتضمينها بحكم التحكيم النهائي. وبهي الحالة بيكون الطرف يلي بنسميه بالألمانية شيتس تروي بارتاي يلي هو الطرف الأمين للتحكيم، هون حسنا نحميه من أي إجراءات خارجية ممكن يتخذها الطرف الآخر. وأيضا بنفس الوقت إذا اضطر أنه يحط محامين في الخارج أنه ممكن الإمكانية بالمطالبة بتعويضات، وبنمنع كمان بنفس الوقت تنفيذ أي حكم أجنبي ممكن يصدر ضده في مكان بلد التحكيم. السؤال هل ممكن اتخاذ إصدار هيك أوامر طبقا للقانون القطري؟ Next. Next please. اوكي. سيكل. هلا السؤال حقيقة لأني بصراحة ما صادفت هيك إجراءات أو لم يتم التطرق إلى هيك مواضيع في الدول العربية حسب معرفتي. هل ممكن الحديث عن هذا الموضوع؟ هل ممكن لهيئة تحكيم مشكلة في دولة قطر مثلا وكان القانون الواجب التطبيق على اتفاق تحكيم القانون القطري وقام الطرف الآخر مثلا برفع دعوى قضائية بالأردن أو بمصر أو بأي دولة ثانية مستفيدا وبسوء نية من أنه القانون مثلا المصري أو الأردني أو السعودي أو السوري لا يسمح بحل هذا النزاع عن طريق التحكيم، وبالتالي الطرف يلي يعتبر حسن النية هون ما حسنا نحميه لأنه الطرف الثاني حسن يروح على محاكم دولته. حقيقة فينا نتحدث عن الموضوع، وهناك إمكانية في القانون القطري بإعطاء هيئة التحكيم سلطة إصدار أوامر بوقف دعوى في الخارج، استنادا إلى أن القانون القطري بيعطي هيئة التحكيم سلطة الفصل في اختصاصها وسلطة البحث بصحة اتفاق التحكيم إلى آخره، وأيضا بيعطي هيئة التحكيم سلطة إصدار أوامر وقتية وتحفظية هي اللي بدنا نستند عليها. ومن هذه الأوامر الوقتية والتدابير المؤقتة والتحفظية حقيقة أي موضوع من شأنه المساس بالعملية التحكيمية. وحقيقة القانون القطري ذهب إلى أكثر من ذلك، بأنه الطرف اللي صدر هذا الأمر لصالحه ممكن يروح على القاضي المختص اللي هو دائرة المنازعات التحكيم في محكمة الاستئناف ويطلب تنفيذ هذا الأمر، والقاضي القطري حقيقة أو القاضي المختص طبقا لقانون التحكيم لا يستطيع رفض تنفيذ هذا الطلب إلا إذا كان هناك مخالفة للقانون القطري وللنظام العام القطري. فهنا حقيقة هناك إمكانية لحماية الطرف حسن النية في التحكيم، وهذا الشيء لازم ممكن بالمستقبل نشتغل عليه، لأن مثل ما حكينا الطرف الثاني علاوة على أنه سيء النية وعلاوة على أنه راح رفع نزاع أمام محكمة ثانية وحب يتملص من اتفاق التحكيم فخرق التزاماته العقدية، فهون بهي الحالة ممكن مثلا المطالبة بتعويضات وإصدار أمر له بوقف الدعوى القضائية في الخارج على الأقل لحتى تفصل هيئة التحكيم باختصاصها وبصحة اتفاق التحكيم. بهي الحالة بيكون هناك حافظنا على وحدة النزاع وعدم تشتته بين هيئة التحكيم والمحاكم النظامية أو بين مكان بلد التحكيم والمحاكم النظامية في الخارج. طبعا هون بنهي محاضرتي أو مداخلتي، وإن شاء الله بصير موضوع للمستقبل للمناقشة.
We thank you, Doctor, for your lovely presentation. Our last panelist today for the third panel will be Mr. Khaled Elgarhe, our board member and colleague. Mr. Khaled is an attorney at law, an international arbitrator. Khaled was a former chief legal counsel at KICA, and he holds an LLM in dispute resolution, and he is a PhD candidate. Mr. Khaled acted as a lawyer, and he's an in-house counsel for several companies. He has over 13 years throughout Qatar and Egypt. He has wide experience in disputes on major projects and infrastructure under Qatari law. Mr. Khaled has also participated as a leading counsel and representative for several clients in different construction, banking, and commercial disputes, including KICA, ICC, LICA. He is also listed as an arbitrator by major regional and international arbitration institutions. Khaled has acted as an arbitrator in several disputes under KICA and DISE. Mr. Khaled is licensed attorney before the Egyptian courts and a member of the Young African Arbitration Association Committee, as he has regularly publishing several articles on international arbitration via Clower and different channels. So, Mr. Khaled, please.
Thank you very much, Shintan. Thank you, Mr. Mohammed. Thank you, MCIArb, for this event, Dr. Nasser, Engineer Saad, attendees today. Quickly, we will highlight practical guidelines for impartiality and independence of arbitrator. Impartiality and independence, as you know, represent a fundamental guarantee for the fairness and integrity of the arbitration process. The issue of impartiality and independence raise a lot of conflict issue, especially in our region. Arbitration, as you know, is a small community, a closed community by somehow. Everyone know everyone. There is no lawyer. Today you are working as a counsel for a company. Tomorrow you could work as arbitrator against the company, or sometimes as an expert and arbitrator in different companies and cases. Impartiality and independence Impartiality and independence are firmly established in most of the national applicable laws and arbitration rules. On Citral, most of the national laws also provided for impartiality and independence. The international or institutional arbitration rules also provide for a clear and sometimes detailed rules for the impartiality and independence. As you can see, is that the approach is different in the arbitration laws. Some laws provided clearly for the impartiality and independence, and the other laws provided a different or indirect approach for the impartiality and independence as a ground for challenging the arbitral award or the arbitrators. But the question, what are the limits of impartiality and independence of the arbitrators? Are they subject to the same rules as judge, or they have to follow a different approach? This matter handled or addressed by different courts, French Court of Cassation and UK Court of Appeal. They provided, or they mentioned clearly, arbitrators should be subject to the same rules, restriction as state judges. However, the US Supreme Court in one of the cases mentioned clearly the arbitrator should be subject to more restriction than judges, since their award cannot be appealed other than the courts, the state courts or state judges' awards. However, we cannot agree to this. Same rules cannot apply, same rules of judges of restriction and impartiality cannot apply to arbitrators. As I mentioned, in our region, small communities, usually the arbitrators are lawyers working as a counsel today, tomorrow working as an arbitrator. Everyone knows everyone in the arbitration community, or most of the people know the others. And that's why we cannot say the same rules of impartiality and independence of judges, of the state judges can apply to the arbitrators. the definition or the definition of impartiality, and before we go to this, the Qatari arbitration law clearly mentioned by indirect way the impartiality and independence as a principle in the Article 11, 12, 18 of the law. So now, what are the definition, or what is the definition of impartiality, and how we can define it? The impartiality means arbitrator should not favor one of the parties over the other, or is predisposed as to the question in dispute. So by somehow there is two function or two different parties for the definition. We will go through them later. The nationality of arbitrator could impair in some cases or in some laws the impartiality of that arbitrator. This issue has been addressed by the Qatari arbitration law and some other laws and rules. Especially the Qatari arbitration law is the Qatari arbitration law provided for the Qatari arbitration law mentioned clearly the nationality of the sole arbitrator or the president arbitrator should be considered or should be taken into account when appointing that arbitrator by the court or the authority, the other authority as per the law. For the exit rules clearly mention the nationality. There is a requirement for the nationality under exit rules, whether the exit convention or the arbitration rules. The convention and the rules mentioned clearly majority of arbitrators on a tribunal must be a national of a state other than the state party to the dispute and the state whose national is a party to the dispute. KICA rules also provided for similar rules with less restriction, as it mentioned clearly the sole KICA, when KICA or the arbitration committee of the center appointing an arbitrator, they shall take into account appointing an arbitrator of a nationality other than the nationalities of the parties or the nationality of the other arbitrator. Also, there is some practical guideline here could be mentioned when the parties or their counsels interviewing an arbitrator before appointing him. This could be, sorry. So it seems, okay. So some, the CIArb rules for provided a guideline for interviewing arbitrator for interviewing arbitrator before appointing them, and as per these guidelines, the parties, yes, can interview the arbitrator before appointing them or before appointing him. However, there is some rules, and the dispute itself shall not be discussed during this interview, and a limited, very limited subject can be discussed, whether the experience of the arbitrator himself or other principles not touching or not concerning the dispute itself. Now we will go to the independence. Independence means the arbitrator, there is no existence or current or past relationship between the arbitrator and one of the parties. The degree of, the other one please, the other slide. Yes. The degree and of the strength and continuity of the relationship between the arbitrator and one of the parties is what indicate whether there is independence or not. And not the mere relationship between the arbitrator and one of the parties or their counsel cannot impair the impartiality or the independence of the arbitrator. The interference of the lawyers and the court expert as arbitrator in a lot of cases here and in the region as well raises a lot of and multiple issues here in this point. We can see in some cases the arbitrator is a court expert or expert appointed by one of the parties in the last 2 or 3 years, and now he's arbitrator or counsel of one of the parties. That's why the impartiality and independence is very important matter to be highlighted. Different countries, also the international law firms, nowadays they have different offices in the region, in most of the countries, and today we can see a lawyer working as a counsel for one of the parties. Tomorrow he could work as an arbitrator in a case where one of the parties or their counsels is involved. Lack of independence is a clear manifestation where or when there are financial interest of the arbitrator in the outcome of the case or the arbitration claim. This can be seen clearly when the arbitrator is a shareholder in a company. And this can be seen easily in many cases. Regardless, he could have a very minor share in the company, or he could have major shares of the company. The major shares of the arbitrator in a company only, but in some court cases could affect the independency of the arbitrator himself. We can see also this issue have been addressed. The relationship between the arbitrator and the parties have been addressed, discussed in many cases before the Egyptian court, the English courts as well. The other slide, please. We will not go through this. The Egyptian Court of Cassation, the French Court of Appeal, the UK courts also provided some practical guideline in this regard. The other one, please. Okay. So the fact that the arbitrator is from a law firm affiliated with another office or another firm in another country, or a partner representing one of the parties, may be a clear reason for the lack of independence of that arbitrator. This has been also addressed in one of the cases before the English court. Also, the French Court of Appeal handled another case similar to this one and provided for a practical guideline here. The other slide. So to sum up is the issue, as Professor Leo mentioned, independence, impartiality is needed to ensure that justice is done. However, the independence is needed to ensure justice is seen to be done through no relationship between the arbitrator and the parties or their counsels. The problem with the impartiality and independence, there is a lack of standard and a clear definition in the laws. Most of the laws haven't provided any clear and standard definition for the impartiality and independence, as well as a practical guidelines as the situation with IBA rules, for example, and the other arbitration guidelines, except maybe for the Swedish arbitration law, which is provided something here. The other slide, please. So, the previous one. Okay. So the lack of impartiality and independence shall be determined for each case separately according to the circumstances surrounding the case itself and the alleged doubts affecting the arbitrator independence or impartiality. The requirement of impartiality and independence may be less obvious in certain type of arbitration, such as the sports arbitration and the marine arbitration, as well as they are very small community handled such kind of matters. So the impartiality versus independency, there is a word provided by the judgment provided by the Court of Appeal, the Egyptian Court of Appeal, clearly mentioned and explain what is the differences between impartiality and independence. The other one. Yes. We already discussed this one. After. Okay, so the duty of disclosure, the arbitrator in some cases has a duty to disclose certain facts to the parties and their counsels where there is doubt about his relationship with the parties or their counsels. The other one. So any relationship may give the impression that the arbitrator may be biased towards one of the parties shall be disclosed. Any professional or personal relationship between the arbitrator and one of the parties or their counsel shall be disclosed as well. Disclosure, there is a standard. Disclosure must include all necessary information. Disclosure obligation exists before the commencement of the arbitration itself, as the arbitrator may be approached by one of the parties to discuss or to be seen as to check his availability for the arbitration and the acceptance. He should disclose at that time any circumstances may affect his independence and the impartiality to the parties. So there is a practical guidelines also here provided by the Supreme Court, the US Supreme Court and UK Supreme Court about relationship between the parties and their counsels versus the arbitrator, and to what limit this relationship and the duty of disclosure of the arbitrator to disclose any relationship with them to the other parties. So any relationship between the arbitrator or the law firm in which the arbitrator works with one of the parties to the case shall be disclosed, whether that relationship is merely an expression of advice or joint action in one of the cases or legal representation in another case. The arbitrator failure to disclose the relationship to the parties may affect the validity of the arbitral award and the arbitrator himself. This has been addressed by the Egyptian Court of Appeal and the Egyptian Court of Cassation as well. So quickly to the practical guidelines provided. The following one, please. So there is international rules and guidelines addressed this issue, while the laws, the national laws, kept silent in certain situations. The international guidelines and rules provided detailed guidelines to address this issue. The other one. So there is a model law already discussed this issue. ICC rules, IBA rules, KICA. MCIArb rules provided, MCIArb guidelines provided some guidelines for this matter as well. The following one, please. Model law discussed this issue in certain provision, Article 12 and 13 as well. The ICC rules provided the general provision to this matter, and there is a guideline, please. There is a guideline also note to the parties and the arbitral tribunal clearly mentioned the duty of disclosure and provided certain practical guideline where that disclosure shall be made and what kind of disclosure will be made. Also, the IBA rules provided certain guidelines addressing this issue. IBA rules, the famous one is the rules of conflict of interest, and there is a rules for the party representation in the arbitration as well, and to what limit their relationship with the arbitrator and their duties to disclose their relationship with the arbitrator, and the arbitrator duty to disclose his relationship with the parties and their representative as well. There is also the IBA rules of ethics for international arbitrators, which provided the very detailed and practical guidelines for the arbitrators' impartiality and independency. The other one, please. So clearly, briefly, we will close, yes. Briefly, this is the element mentioned in the IBA rules. The IBA rules provided, this is too close, IBA provided 3 lists, the red list and the orange list and the green list, and arbitrators, and the red list is divided into 2 lists, waivable list and non-waivable list, and the orange list provided for certain situation, a detailed situation when the arbitrator shall shall disclose to the parties has a relationship with the parties' representatives or the parties' counsels or the parties themselves, and the arbitrator under duty to disclose his relation, this situation mentioned in the orange list, and however in the green list there is a situation provided also practical guideline where the arbitrator has no duty to disclose his relationship with the parties or their counsels. There are some other slides we will go through. We will not discuss them, just for to keep it. Yes, please, the other one. This is the red list, as I told you. Thank you very much for this. Thank you, Saad. Thank you, Dr. Nasser. Thank you, everyone.
We thank Mr. Khaled for this interesting topic. I believe to keep up with the time, we would like to welcome now the Vice President of MCIArb Qatar to hand over the trophies to our panelists. I would like to ask the panel for a memorial photo, and we will have a small coffee break for 10 minutes, and we will start our next session. 15 minutes. 15 minutes.